We'd like to take roll call, please.
All right, I'll go ahead and call roll. Mr. Hartman?
Present.
Ms. Weber?
Here.
Mr. O'Malley?
Here.
Mr. Zobel?
Present.
Mr. Gerstein?
Here.
I'll let the record show that 5 board members are in attendance. Also, within the panelist discussion, we do have City Council Liaison Gregory Carl in attendance, along with City Attorney Paul Martin, and the City Prosecutor, and representing the city also is Mr. Ross.
Great. I would like to just let everybody know out there the way it works there. It takes 4 votes out of 5 to pass. It's kind of unusual tonight. We will hear from everybody. We'll read the applicant, and then we'll have a public session where everybody will get a chance to speak, and then we will close it to a private deliberation, and we will reach a decision at that time. Can we have somebody read the notification, please?
Mr. Chairman, if I can interject, what I'd like to do is first list exhibits that I'm going to call the appeal exhibits. These are all exhibits except for one that I'll talk about that have been included in the on the city's website in full. And I want to identify those exhibits and ask if there are any objections to any of those exhibits. And then we will turn it over to the petitioner and allow the petitioner to proceed with his case. And then that will follow up with Mr. Ross Davis. The petitioners are represented by Mr. Steve Kling, and he is going to be joining us very soon. Ross Davis is representing the city here, and Mr. Trejo. We also have the property owner, Richard Kellner. Mr. Kellner is not represented, at least to my last information was not. And I'm representing the Board of Adjustment. I'm here to offer you advice and counsel on procedural matters, evidentiary matters, and other issues that come up. So I'm kind of advising you and trying to get you through all of this. So with that brief introduction, I would like to introduce the appeal exhibits. And remember, the Mr. Kellner might have exhibits of his own. Mr. Kling might have exhibits of his own. Mr. Davis might have exhibits of his own. But we're starting with the appeal exhibits because I think that everybody's going to agree. I think we can agree to these, at least that they are what they purport to be. So the first exhibit, Exhibit A, is the Board of Adjustment appeal petition. And that's been filed by the Elizabeth S. Little Revocable Trust, the Sean M. Rochester and Carolyn S. Rochester, Curtis Van Allen and Catherine Van Allen, Jason Koenig, and the Jason Koenig Revocable Living Trust. And that has a date of October 22. It includes a letter of their attorney, Mr. Kling, and it is challenging the issuance of a building permit for Mr. Kellner's property at 508 North Warson Road. So the petition is Exhibit A. Exhibit B is the city's notice of public hearing, and that includes the affidavit of publication and the individuals who were notified of this hearing tonight. Exhibit C is Mr. Kellner's building permit application. That would be permit P 2020-00774. Exhibit D is the staff memorandum prepared by Carlos, and the legal part of that, if it confuses you, that's my fault because I prepared the legal part of that. Exhibit E is Mr. Kellner's statement that he wanted shared with the members of the board, and this goes back to let's see. It's attached to an email string that ends with my email to him dated Friday, November 13, 2020. That's Exhibit E. And I believe Exhibit E is not included on the website. The same statement, though, is included in the petitioner's list of exhibits. And Mr. Kellner and Mr. Davis both are aware of this exhibit. We've shared it all with them. Exhibit F is Mr. Kellner's second submission to the board, and that was, I believe, submitted on Friday. I don't know exactly when that was submitted. But Exhibit F consists of it's called Response to Pole Permit Challenge, Richard Kellner, owner, 508 North Warson Road. And Exhibit G. Exhibit G are comments, emails, and a letter received to date. Again, published on the website and available for everybody to inspect. Exhibit H is going to be the city's code of ordinances, and that includes, in particular, what I have called out as Exhibit H1, which is Section 400.020, the definition section of the zoning code, and Exhibit H2, which is Section 400.1590, and that deals with accessory structures in the zoning code. And Exhibit I is going to be the city's zoning map. Exhibit J is the city's comprehensive plan. And the reason for going through all of this, folks, in case you're not aware, is that if this would go to the St. Louis County Circuit Court, we need to keep track of all these exhibits so they're readily referable if we get in front of a judge, so that everybody knows what we're talking about. The exhibits that I've just read, I have paper copies. The paper copies are not complete. For instance, the petition does not include all of the attachments to Mr. Kling's original letter, but those are all on the website, and those would be considered, in my mind, as included in the exhibit. And of course, things like the zoning ordinance and the comprehensive plan and the zoning map, we don't have separate copies of those. Those are all on the website as well. So with that, I'd like to bring in Mr. Kling and Mr. Davis and Mr. Kellner as participants and ask if any of them have any objections to those exhibits.
No
Right.
objection from the city.
That was Mr. Ross.
That was Mr. Davis.
Okay.
Both Mr. Clean and Mr. Kellner have been brought up to as panelists.
Mr. Kellner, are you there?
Paul, I am. Hi.
Do you object to any of the exhibits that I've just identified?
No, I believe that the ones that I submitted, I believe of the number of the several that I submitted, 0 are on the website.
They're posted.
They are posted. I just checked them a few minutes ago.
Okay. They weren't as of 5 minutes ago.
But if we need to supplement something, if you're concerned about that, we'll certainly do that.
Okay, thanks.
All right. Mr. Kling, are you there?
I am here.
Any objections to the appeal exhibits?
No objections.
All right. At this point, I'd like to, Mr. Chairman, I think it'd be appropriate to just turn it over to Mr. Kling and let him make his presentation on behalf of the petitioners and the appellants. And he can explain in detail what this is all about. I mean, I can tell you generally, a building permit issued for the construction of poles and a fence. And the poles are, the intent of the poles is to use them to secure netting that would serve as a backstop of sorts for a batting practice facility. It's not exactly a batting cage because the facility doesn't have fencing all the way around it. It has netting all the way around it. But there are 4 poles in the corner, and the petitioners appealed that building permit claiming, and I'll let Mr. King go into more detail on this, but essentially claiming that this is an accessory structure that is not subordinate to the principal residential use. And he can go into that in more detail. Is that okay with everyone, that process? Any objections to the process?
No objections.
All right. Well, Mr. Chairman, if that's okay, I'd turn it over to Mr. Kling. Oh, by the way, I would ask, why don't we have a group swearing in? I do not know exactly what anybody's going to say, and this testimony is supposed to be sworn. So if Mr. Kling, Mr. Davis, Mr. Trejo, and Mr. Kellner could all raise their right hands and take the oath administered by Karen, that would be fantastic. And then we can go to Mr. Kling.
You solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
Kling, you're up.
Yes. All right. I also need my associate Abby Schauberg. She'll be putting the exhibits up on the screen. So if someone would give her permission to do that.
She's being transferred right now, and then I will provide her access to the.
Will
Okay,
she need to be sworn in as well?
I don't think so I mean, you can swear her in. I think most of the exhibits are city documents, but if there's a question, we can have her, and I will, I have some clients, two of which who want to give brief statements. I don't know if you want to swear them in now or when they.
We'll wait.
Okay,
We'll wait.
fair enough. Let me know when Abby's been given permission to access documents.
Ms. Schauberg should be set. She's transferring over, and there we go.
Okay. All right, let me start it off. My name is Stephen L. Kling Jr. I'm an attorney with Jenkins and Kling PC. Offices at 150 North Merrimack, Clayton, Missouri 63105. I also have on my associate, Abby Schauberg, who will be handling the exhibits. I understand we have a court reporter. I have done several of these hearings already, and I'm familiar with the problems that can arise and slow me down if need be in terms of trying to keep pace. I'll be happy to do that. As mentioned, I am representing the Elizabeth Little Revocable Trust, the Jason Koenig Revocable Trust, Sean Rochester and Carolyn Stein Rochester, Curtis Van Allen, and Catherine Van Allen. As this is an administrative hearing and conducted by Zoom, and as I discussed with the city attorney to move this along much more quickly, I'm going to proffer our exhibits into evidence, identifying who obtained them or took the pictures. I will make all such people available for questions or verification if needed, but most of the exhibits are public records, speak for themselves, and require no testimony. This should greatly shorten our presentation. A few of the clients want to speak, and I've asked them to be brief and not repetitive. All right, I see that we already have petitioner appellants exhibit 1 up on the screen. This is the Olivet zoning map. The purpose of this, the circle there is around Mr. Kellner's property and my client's property as well. All of those properties are zoned SR, single family zoning as shown by this map. Abby, if you could put up petitioner appellants exhibit number 2, please. This is section 400-220-280. This is the SR zoning district, single family zoning district in which Mr. Kellner's property is located. SR zoning only permits a house, a church, and accessory structures and uses. No other structure or use of any kind is listed as permitted in the SR district. There is no provision for discretion or interpretations to permit any other structures in the SR district. Abby, if you could put up petitioner appellants exhibit number 3, please. This is first the face page from the city's website, and then it provides a link to the 2015 International Residential Code, which is the building code adopted by the city of Olivet. Chapter 1 is copied here. I want to point out a few sections. We can go to them if you want, but I'll give you the overview first. Section R1022 provides that the building code shall not be deemed to nullify any provision of local, state, or federal law. And in section R105.4, it provides that permits presuming to give authority to violate or cancel provisions of this code or other ordinance of the jurisdiction, which obviously includes the zoning code, shall not be valid. Also, section R101.2 scope says that the code only applies to houses and accessory structures. No other kinds of structures of any kind are stated to be within the scope of the building code. All right, if we could go to petitioner appellants exhibit 4, please. This is an aerial photograph from Google prepared by my associate, Abby Schauberg. It's there for informational purposes. Mr. Kellner's property is there outlined in yellow, kind of in the middle of the picture. To the north, which is to the right side, we've identified where the petitioner's properties are. Abby, if you could put up petitioner appellants exhibit number 5, please. These are pictures taken by my client, Liz Little, who was on the call in early September from her backyard showing metal poles being set out in concrete. There's 4 pictures. Yes, if you could just kind of scroll through them slowly. Is that it? I think there's one more. Yeah. All right, thank you. If you could put up petitioner appellants exhibit 6, please. This is a June 18, 2000 email from Mr. Kellner to the city with an attached drawing obtained by my associate from the city records through a sunshine law request. And if you'll go to the drawing, there's a drawing that was attached to it. Put that up on the screen, please. Thank you. The drawing submitted to the city shows Mr. Kellner's house. Abby, you'll have to scroll down just a little more for a second so we can see the house. There it is. Okay, you can go back up if you want. And a proposed batting cage rectangular structure up towards the top. In the notes next to that's referenced the batting cage, it notes that the purpose of the poles being a batting cage and 4 metal posts to, quote, support corners for batting cage. He also goes on to mention there's 3/4 inch wide heavy duty galvanized airplane wire along both sides of the length. Abby, if you could put up petitioner appellants exhibit number 7, please. This is a September 14th, 2020 email from Carlos Trejo to the city administrator, obtained by my associate through a sunshine law request. This confirms the dimensions of the batting cage are 14 feet high, 70 feet long, and 14 feet wide. Doing the math, that's a 980 square foot footprint. The email also states that, quote, poles serve as the end poles for a batting cage, end quote. And, quote, the poles will serve as ground ends for overhead netting, end quote. The poles are also confirmed in this email to be set in 18-inch wide concrete pours dug 47 inches deep. If you could put up the next set of pictures, let me describe them first and then we can come back to them. So what this is are pictures of comparable batting cages obtained by my associate from batting cage manufacturer websites. She was assisted by her husband, Brad Bishel, a former scholarship baseball player at Cameron University in Oklahoma, and now a high school head varsity baseball coach. Go back, you're going a little too fast there, sorry. The first, just quickly, so this is the Grand Slam safety page. There's the first page there. You can start scrolling now. There's a small picture there. We've blown it up to give you an idea of their batting cage. If we go to the next one, these are the King Kong outdoor batting cages. And if you'll scroll down a little more, there's a blow up of one of the pictures there to give you an idea. And you can see the 4 poles on that one. If you go to the next one, stop there. This is another site, and the reason we have it up is that it gives you the various sizes of the batting cage. You can see of all the options there, there's certainly smaller ones, but the largest one is 70 feet in length, as Mr. Kellner's cage is, as confirmed by Carlos Trejo. You can go to the last page, please. Thank you. This site is up there. This is a 70-foot cage. And if you'll look towards the bottom there under description, it says that, there it is, the 70-foot size is described as, quote, used for schools, training facilities, and any heavy usage environment. You can go to the next petitioner appellant's exhibit number 9, please. This is the building permit. It was issued on September 15th, 2020. It says nothing about a batting cage, but approved poles that were known to be solely for and as part of a batting cage, as indicated in Carlos's email one day earlier, which was petitioner appellant's exhibit 7. You can see on page 1 there, somebody marked in blue print plus post poles right there. And then if you go to the last page, one more, there you go. You'll see there that somebody marked 14 there for the setback. If you'll go to petitioner appellant's exhibit 10, please. This is an email, November 14th, 2020, email from the city attorney to Mr. Kellner with copies to me and others. It states that the city attorney told Mr. Kellner months ago that if he installed poles for his batting cage and attached his net to them, it would be an accessory structure requiring site plan and community design review. I would also note that there's quite a number of letters submitted in this proceeding. I believe they're all on the website now by others besides my client opposing the batting cage, which would not have occurred if it was just a matter of a few innocent poles. Abby, if you could put petitioner appellant's exhibit 6, yeah, there it is, back up. I'm going to refer to this as I go through my argument. First point, a building permit cannot authorize and enable what the zoning code does not permit as a use or structure. And neither can an interpretation by an administrative official under the building code. Zoning codes are legislative laws and the primary law of land use and can only be varied if discretion is clearly granted in the ordinance. The building code expressly subordinates itself to the zoning code. So there's no interpretative authority under the building code that can supersede the zoning code and allow and approve structures in the zoning code doesn't permit. The only interpretive ability relates to whether the structure is a home, a church, or an accessory structure. The poles in the batting cage clearly are not part of a home or a church. And I also want to mention, because this email wasn't mentioned, Paul, city attorney, and I want to clarify this before I go on. By a set of emails that went out over the weekend, we were directed that the only issue that was going to be argued tonight was whether or not the poles and the cage and the permit were a accessory structure, and that the city had conceded that if they are, then they have to go to site plan and community design review. And I just want to confirm that because I have emails to that effect.
Yes, that is correct. If it is determined that the poles are an accessory structure, the city is conceding that they would have to go to site plan review.
All right, thank you, Mr. Ross. The city cites a flagpole, a basketball backboard, and a playhouse as examples of its interpretive authority under the building code to permit additional structures not allowed in the SR zoning. As previously mentioned, the only way any of those examples is permitted is if they're part of a house, church, or accessory structure. Olivet's zoning code already lists play structures as an example of an accessory structure, which would include a playhouse. I would point out that the neighboring city of Creve Coeur lists both playhouses and basketball backboards as accessory structures in section 405-740 of its zoning code, and has a separate section allowing flagpoles in any zoning district. Similarly, the neighboring city of University City includes both flagpoles and playhouses as examples of accessory structures in section 400-10080 of its zoning code. The city's examples do not support discretionary decision-making on new structures in SR zoning, and all examples cited by the city are typical accessory structures. As already noted in petitioner appellant's exhibit 10, the city attorney, the chief legal authority for the city, has already stated that the net tied to the poles is an accessory structure. Some additional points. This is 4 poles, not 1, and they're placed apart to square up a 3-dimensional cage and support the corners. The poles are embedded in 18-inch wide concrete pour dug approximately 47 inches into the ground. Metal poles that deeply embedded are only to support something large and heavy. They're clearly structural components of the batting cage. The poles support and are part of a 980 square foot batting cage, 70 feet long, 14 feet high, 14 feet wide. And you can tell from the drawing and petitioner appellant's exhibit 6 and other evidence, it's bigger in size than Mr. Kellner's porch, his patio, or his garage. It has 5 sides like a building and includes a ceiling. The poles have no independent purpose and serve no other purpose but to support a 980 square foot batting cage. The city's argument that these are independent poles directly contradicts the evidence and that the purpose and use was well known by city officials. The poles in the batting cage are 450 feet away from the house and cannot be considered part of the house or a single family use. Staff suggests the cage is not a structure, but simply a net hanging from trees and tied to a pole, each pole. That ignores the clear stated purpose as a fully enclosed batting cage that requires 4 metal poles to support it. If it's merely a net hanging from trees with independent poles, then it's an illegal fence in excess of the 6-foot maximum requirement under residential zoning. Even if the 4 poles are somehow not enough by themselves, the definition of structure in section 400-020 of the Olivet zoning code includes anything constructed or erected, the use of which requires a permanent location on the ground or that is attached to something, of course something means anything in this instance, having a permanent location on the ground. There's no limitation that the something to which the erection is attached has to be artificial or man-made. The metal poles are obvious, but the trees are also a permanent location on the ground. They can't be moved, and like a house or a fence, are a permanent part of the real estate when sold. So the net structure attached to the trees in addition to the poles is also an accessory structure and needs legal and proper review and approval. Attaching something to a tree does not magically exempt it from an accessory structure and having to comply with the zoning of the property. The net also has a permanent location on the ground, making it a structure without any poles or trees. There's a reason why the Olivet Code has site plan and community design requirements for uncommon and unusual accessory structures and uses. And that is to properly evaluate all aspects of the structure and intended use with detailed plans and consider their impact and what screening or limitations might be needed. The city did not even require any detailed plans to see how this would work and what it would look like before they issued the permit. The city's rationale to rely on some ad hoc interpretation to approve the poles and attached cage also led it to allow the placement of the poles and netting within the side yard setback, better yet with no screening whatsoever. The property is over 150 feet wide per Mr. Kellner's drawing. And under the SR zoning district, the setback must be no less than 12% of the property width. That's over 18 feet. No structures are allowed in the side yard setback except in limited circumstances like a residential fence. Yet the permit allowed the poles to be only 14 feet from the side property line. This is another reason why such structures cannot be approved on an ad hoc basis and should have gone through a proper review process. Before I go to my conclusion, I do want to point out the law of estoppel and vested rights. There is no estoppel or vested rights in an improperly issued permit. There are numerous Missouri cases that make this abundantly clear, and this applies even if the structure is built or fully completed. I'll give you the cites of Fleming versus Moore Brothers and State ex rel Rabineau versus Beckmeyer. Can provide the rest of the cites if you want. There's probably a dozen more cases in Missouri holding the same way. All right, I'll go to my conclusion now. The city suggests these are just random poles tied to a net and can be arbitrarily approved by an internal policy or building code interpretation that directly contradicts the zoning code. There's no legal authority for such a position, and any interpretive power under the building code is expressly subject to and cannot contradict the zoning code. The building code states it only applies solely to houses and accessory structures. There is no phantom other structure permitted anywhere in the zoning code or the building code. The evidence clearly shows the poles are part of a 980 square foot structure, which is only permitted on the property if it's a proper and legal accessory structure following all the proper processes. It is not, as it is not a part of a home or a church under any strained interpretation. The poles serve no other use but as part of a three-dimensional batting cage. Each pole itself is a structure as admitted by the city, and each by themselves are also impermissible under SR zoning unless part of a home, part of a house, or a legal accessory structure. Since the poles aren't part of a house or a church, by default, they can only be an accessory structure. For all these reasons, the building permit improperly approved the poles and batting cage without following the procedures for accessory structures, including site plan and community design review. My clients are not waiving the right to later question the cage as being a legal and proper accessory structure or its placement, screening, and use. And use, specifically reserving all such rights. I would also ask that all my exhibits, petitioner appellant's exhibit, the entire city zoning code, and the residential building code be made part of the record. Thank you.
Thank you. Any questions for this gentleman?
I also have clients that want to speak too. I don't want to forget about that, but
But yeah, we'd like to ask you first and then we'll go.
Sure, go ahead.
Anybody have any questions, please? All right, let's move on. Have your,
Liz Little, I think you can speak next if you're on. I can't tell if you're on, but I presume you are.
Okay, I'm going
you
to
need
bring
to be
this little,
sworn in, please.
as each one is brought in, I'm transferring them from an attendee to a panelist, and if they can get sworn in. And then after their comments are done, and if the board has any questions, I'm going to bring them back to an attendant. So right now, Ms. Little, I'm going to transfer you over. Bear with me 1 second. Okay, Ms. Little.
There we go. Can
Okay,
you hear
I
me?
can have you sworn in first with the court reporter. Yes, 1 second here. Ms. Little, I do need your video on.
Okay, and
It
let's
should
see.
be on the lower corner of
Oh,
lower
there I
left
am.
corner.
Okay.
All right.
Little, could you raise your right hand, please?
Mhm.
You solemnly swear affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
And can you state your name and affiliation with this, please?
Yes. My name is Liz Little, and I reside at number 3 Lisa Drive.
Perfect.
I am one of the neighbors who is directly affected by this structure. The batting cage, batting nets, or whatever is being identified tonight is literally spanning the entire length of my usable backyard. The poles are 14 feet high and run 70 feet long, and one of the poles is actually within 10 feet of my property boundary. That is the entire length of my usable backyard, the entire view from the rear of my house, my family room, kitchen, bedroom window, and deck is the area that Mr. Kellner intends to use as his batting area. It directly impacts my home and outdoor space. I cannot and have not been able to enjoy my outdoor space since he started work on this 2 years ago. I cannot entertain, I cannot garden, I cannot spend time outside with my son without being impacted by his grading, the debris, and most importantly, this structure. As you've seen from the photo shared earlier, you can view the span of the poles in my rear yard. Out of his 2-acre property, he could not find a more suitable area to place this structure. I had my rear yard staked out in September by Marlar Surveying Company when I did extensive landscaping. And I measured from my stake to this pole that you're looking at, and it is at 10 feet. This situation, I believe, needs to be properly governed by the city of Olivet. And it needs to go through the proper channels and have clear communication of a site plan review as discussed earlier by Mr. Kling. If it's not a batting cage, then what are the metal poles for? And if he's hanging nets from the trees, which are higher than 14 feet, spanning again the length of my yard, don't I have rights as a property owner? And what would keep me from doing something just as offensive in return? Batting cages, batting areas, baseball diamonds really belong at schools and parks and professional facilities like 314 Training Academy, which is very close to where we live. It does not belong in backyards. I really want to be clear here. I don't want poles, I don't want netting or any apparatus spanning the width of my yard, really regardless if it's permitted or not. He has completely destroyed my privacy, my capability of using my yard, and basically has complete control over my house. I will not be able to get away from it. I can hear him now inside my house when he is using commercial equipment to grade his yard. I will definitely be hearing kids with metal bats hitting baseballs and coaching from inside my house. This is beyond maddening. The structure is not appropriate for the neighborhood, and my property value has been adversely affected by this structure. I could not sell my house at this point if I wanted to. I can only ask, would you want this in your backyard? And I'm hoping we can all use common sense tonight and realize this is inappropriate. And Mr. Kellner used a previous permit application for a fence to claim a permit for unidentified poles for a batting cage. Thank you for your time and consideration.
Thank you. Any questions? Next.
Could be Sean Rochester. Sean, are you on? Or, I'm sorry, Carolyn Rochester.
Okay, 1 second. I'm gonna,
Or it could be
Okay.
Carolyn Stein too.
okay. 1 second. Okay, Mr. Rochester, you should be transferred over as a panelist.
Okay,
And
can
if
you
I can have you state your name and address, and then get sworn in by the court reporter.
Yes, my name is Carolyn Rochester. I live at 0 Lisa Drive.
Would you raise your right hand, please? You solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Thank you for your time tonight. I had a conversation with Mr. Kellner when I brought over the welcoming chocolate chip banana bread that I bring to our new neighbors. And we were making introductions as he moved in. He told me of his plans for his backyard, which included a plan to build a sport court in the back, including a baseball, basketball, and batting cage for his children and their sports teams, as well as additional parking. I recall this conversation because I remember thinking how this would affect the safety of my family if multiple sports teams would be parking and driving and hitting high-speed baseballs behind our house. I'm urging you not to allow Mr. Kellner to have his batting cage accessory structure behind our house. These batting cages belong in parks and in schools and other indoor facilities. On one hand, he's claiming he's simply hanging nets from trees. However, this is not the case. He needs poles that are set in concrete in order to complete this batting cage structure. It is not just hanging nets from trees. He's also stated to Olivet that he's planning on using 3/4 inch airplane wire to help hang this net. That wire is extremely heavy duty. Why can't we see a picture of what he is intending to build to clear up the confusion? Why can't he and his children use the batting cages at MICDS where his children attend and is less than 0.4 miles away? Why can't he and his batting teams where he is the assistant coach use the 314 Training Academy that has indoor batting cages located a few miles away? This batting cage structure will be a nuisance to our residential property use, reduce our property values, and be a safety issue to my children, both with flying balls, with the noise of batting balls being hit with aluminum bats, a potential pitching machine running at all hours. We don't want to hear baseballs hitting aluminum bats, pitching machines, sports teams in the backyard. I'm urging you, the board, to vote that this batting cage does categorize as an accessory structure and does need to go to site review. Thank you so much tonight.
Thank you. Anybody else? No?
Bear with me 1 second, Chairman.
Okay.
Takes a second to make sure anybody else, there is one more hand raised.
All right.
And Alan Roden. Mr. Kling, is that part of the,
He's not one of my clients. He may be someone who received your public notice hearing.
do we want to have the public comments?
Mr. Chairman, do you want to hear Mr. Woden at this point, or do you want to wait until we hear from the city and the property owner?
Yeah, I would rather hear from the city and the property owner.
Okay, before we turn it over to the city, again, just to keep clear, something that I'm notoriously bad at is exhibits. The city, I have identified appeal exhibits A through J, and Mr. Kling has identified petitioners exhibits 1 through 10. By the way, I've been notified that the link on the website does not go to Mr. Kellner's documents, so that is a mistake on our part, and we will get it remedied. I do have paper copies of the materials from Mr. Kellner. One is, as I said before, is Exhibit E. That consists of a statement to the Olivet Police Department, and it was an attachment in an email from Mr. Kellner to Mr. Trejo, Barb Sondag, the city manager, and me on November 13, 2020, and my response on November 14, 2020. That is functionally the same exhibit as petitioner's Exhibit 10, I believe. And the second exhibit that we have, Exhibit F, is a 2-page exhibit from Mr. Kellner, response to poll permit challenge. And I am not sure if we can get this scanned and available to Mr. Kellner right now.
It's been updated. The link has been corrected.
Link's been corrected? Okay, so now the link has been corrected and it is on there. Okay,
And I do have one of the petitioners, one of the individuals that the petitioner was on, Mr. Van Allen. He's part of Mr. Kling's group.
okay,
Yes.
let me finish up with the exhibits before I forget. So, Mr. Chairman, we've got appeal exhibits A through J and petitioners exhibits 1 through 10. And I believe Mr. Kling wanted to include the residential building code as a whole as part of the record, and that would be Exhibit 11. So if there are no objections to all of those exhibits, I think you can accept those exhibits as evidence.
Absolutely. Thank you.
Paul,
Yes.
I also asked for the zoning code to be entered. I don't know if you said that already, but I want to be clear.
Yes.
One entire zoning code. Okay, thank you.
Yes. Okay, sorry for the interruption. Now, Mr. Chairman, it would be appropriate to hear from Mr. Davis if the city wants to put on any information, and then from Mr. Kellner.
Mr. Martin, 1 second. There is one more petitioner,
Oh.
one more individual from the group of petitioners.
What's his name?
All right.
Mr. Curtis Van Allen.
Mr. Kling, do you want Mr. Van Allen to testify as well?
Yes, he's one of the clients and one of the petitioners.
Fine.
Well, before we go to the city, why don't we go to Mr. Van Allen?
Yeah, let him be sworn in, please.
Bear with me 1 second. Okay, Mr. Van Allen, you should be transferred over.
Could you raise
Can you hear me?
Could you raise your right hand, please?
Yes.
Do you solemnly swear from the testimony about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
I want to be respectful of everyone's time. I just wanted to really echo what everyone else is saying. I've lived in a lot of different places, multiple countries around the world, and had a lot of different neighbors. And I've never experienced such blatant disregard for one's neighbors. The whole neighborhood is tired of all the noise, and what looks like will be permitted to be more noise. And I think a continuance of wasted resources. I think if the residents have to complain constantly to the police department, I guarantee you the police have better things to do with their time than to come out here and deal with our complaints. And I think a continuation of an allowance of a continuation of his activities, Mr. Kellner's activities, it was just a continued waste of everyone's resources and an impingement on our rights and freedoms, I think. I have a similar view, not quite as impeded as Liz Little's, but we see the polls from our backyard, and we've had a similar experience where neighbors were at 2 Lisa Drive, and it's difficult to sit on our back porch and and enjoy it because our view has been decimated. And there's constant noise, and I think there'll be it sounds like a potential for continuation of constant noise. You know, and that's an issue. And again, to echo what Liz Little said about you know, degradation of property values, you know, it's a concern. Thank you.
Thank you. We'll hear from the city next.
All right, thank you. Ross Davis, I'm here representing the city. I'm going to present evidence through some questioning of the building officer, Carlos Trejo. And then from that point, we'll move on. But as stated before, this really does come down to whether the putting up the 4 poles constitutes the erection of an accessory structure or not. This was a decision that went to Mr. Trejo. He determined that this did not come to the level of an accessory structure, and he proceeded to move forward accordingly. With that, I would like to call Mr. Trejo. And
Joe's been sworn.
Carlos, can you hear me? I can see you in the corner there. I just want to make sure.
Yes.
And Mr. Trejo, you were the individual that ultimately approved the permit issued on September 15th, 2020, correct?
That is correct.
And can you provide us a little background as to the information that was provided to you leading up to this decision?
The permit initially started with the placement of the 4 posts, separated about 14 feet by 70 feet in length, going east to west. Initially, the description was regarding the hanging of a netting or on some existing trees that are located at the northeast corner of the property grounds. And in that case, they're, you know, looking through the building review and the IRC and IPMC as adopted by the city of Olivet, we didn't see that as a structure requiring a permit. We treated it no differently, as noted in my report, as a structure or an activity such as a playhouse, a post for a backboard, or a hammock.
Mm-hmm.
In that, the posts were embedded in the ground, and that was brought to our attention by one of the neighboring property owners. Taking a look at that and given some of the history regarding this site, decision was made that a permit would be necessary for those posts, being that they were embedded in the ground. I do agree that they met the definition of a structure as defined both by the building code and the zoning code. But in terms of considering the netting and the placement of that, there was really no structural interconnection that we felt within those posts and sites that would require a permit. When we look at the issuance of a permit, and that's not what is on the table, it's also what value we're bringing into the process of a resident is paying a fee for a permit review, and we look at that balance in terms of what what professionalism or insight we bring in from the building code, structural requirements, and things of that nature. The posts were in the ground, and therefore they are subject to specific depths and to meet frost codes. And we went ahead and issued the permit on that. Looking at it from a zoning perspective, again, question the process of whether the structure, these 4 posts represented, were subordinate to the primary structure or serve the primary structure on the property ground. Again, we have to make decisions in terms of when when does a structure become an accessory, or when does an activity become an accessory? There's no questioning regarding what the primary use on the property is. It's a single-family residential use. But there are driveways, there are sidewalks, there are landscaping, there are trails, there are trees, and there are these 4 posts in place. And whether the intent of the zoning ordinance is to regulate those placements or activities associated with those placements, was something that we looked into and didn't find that it met, the full definition of the accessory structure. And again, that was an interpretive opinion on my end for that. We looked at, what our past precedent, past procedures and policies have been on those. And we have a history that, we've been lenient on tree houses. We've been lenient on back posts for basketball courts. But when there is if the posts were interconnected with more than just the 4 corners on the ground and net hanging from a tree, I think we would look at that differently. When we see a tennis court, it has a slab. A slab requires a permit. There's no question about that. The posts that are embedded in the slab, the netting, is all integrated in one. When we looked at this and the 4 posts, or the so-called batting cage, it was a call based on how we viewed and looked at these types of structures in the past. And again, I think the process of looking this and going through a decision tree to get to the point of saying whether it met the full definition of an accessory structure, and therefore is it enumerated, and therefore does it require the additional review and approval to the Plan Commission. We went and had that discussion. We looked at the evidence that was submitted through the permitting and such, and came with the decision that we would not consider it as an accessory structure under the conditions that it was described.
There was some reference in Mr. Kling's argument with regard to some other cities' municipal codes with regards to flagpoles and playhouses and things like that, and how they may have been considered accessory structures in those municipalities. That's not the case here in Olivet, though, correct?
That's correct.
And as you said, traditionally, you've given residents some leeway in these scenarios as to avoid overregulation of the residents of the city.
That is correct. We take a look into it in terms of what is the services that we're providing, and the key service is, of course, public health, safety, and welfare. And in these cases, in the case of the 4 posts, it was again a decision that was made based on the evidence submitted, that the value of services that would be provided, whether through a permit or through site plan review, were not met.
And as far as when the application came in, there was a professional land surveyor that provided some records to you showing that it did include 1 parcel of land, correct?
That is correct.
Okay. And when you received that, that is sufficient for you to determine that that is a single parcel of land for the purposes of determining what's going on that piece of property.
That's correct.
With regard to what we're talking about here, there was, as you said, a kind of a decision tree that had gone down in a discussion amongst the staff whether this was going to rise to the level of an accessory structure. Ultimately, you made the determination that the netting that hung over the top and the sides was not rising to the level of calling this thing a structure for the purposes of what an accessory structure under your interpretation would be, correct?
Correct.
Okay. And as we said before, we are not trying to shoehorn this in to any definition of an accessory structure. It was specifically your determination that it did not rise to that level.
Correct.
City has no further questions for Mr. Trejo at this point.
Any board members have any questions for Mr. Trejo or the city attorney? Before we hear from Mr. Kellner.
Are we going to be able to circle back? I feel like we're taking in a lot of.
Yes,
Okay. Yeah, I'll hold my questions off.
perfect. Can Mr. Kellner please be sworn in?
Might be just a matter of form, but you should ask Mr. Kellner and Mr. Kling if they have any questions for Mr. Trejo.
Did you guys hear that? Anybody else have any questions for Mr. Trejo?
I have a few questions for Mr. Trejo.
Thank you, Paul. Thank you. Speak now.
That's
This
Steve.
this is Rich Kellner. I do have a clarifying question for Carlos, if that's okay.
Before, can you be sworn in now, please, as long as we might as well knock it out.
Okay, sure.
I'm sworn.
He's already been sworn in.
Yeah, Mr. Kellner's already.
Yeah, I was at the beginning too. I'll do it again.
I'm sorry. Thank you.
Okay.
You may ask, yeah, if you have questions for Carlos, and then you may just continue with whatever you have
Oh,
to
thank you.
state your.
Okay, thank you. I guess the clarifying component for Carlos that I wanted to ask is, was our process completed with the town involved in each step? Meaning the town legal opinion, the town planning and development opinion, and the town executive's opinion.
There were prior discussions that involved other matters through the process. I think the end result of the permit was issued, again, was different than what the discussions was with the city attorney earlier on. I think ultimately what we were called in for, I believe it was sometime in October or so, was about the placement of footings for the post. And at that point, making the request that a permit would be necessary for those footings. We had prior discussions, yes, before the requirement for the permit. And those were based on descriptions that took place at that time. I think what we had here and what's being appealed is specifically, the building permit as it was issued, and those 4 posts being looked at as a larger assemblage and becoming an accessory structure within itself. We didn't have that discussion with the city attorney. We had a discussion about the netting overhanging on the trees and what that represented.
Okay. Thanks, Carlos. Shall I get started?
Please.
Okay,
Mr.
thank you.
King had some questions.
Yeah, I had
that
some
he
Thank you, Mr.
wanted
Steve
to-
Killing.
I'm not.
I've only got a couple, so it'll only take a minute.
Okay.
Carlos, have you ever approved a 70-foot batting cage in residential zoning district in Olivet before?
No, we have, to the best of my knowledge, there is no history of any batting cage.
Okay, so this wouldn't be a typical approval, would it?
No.
Can you tell me where in the SR zoning text there is authority for anything other than a house, a church, or an accessory structure?
Within the zoning ordinance, there
The
would be
SR
no,
zoning district, yes.
correct. Within our accessory uses, we have some identified, what we consider accessory structures, which represent specifically, things that are subordinate or supportive of the primary structure. A
But what I'm
batting cage is
asking-
not called out. If your question is whether a batting cage is called out.
No, that's not my
it's
question.
not.
My question, and I'm trying to be as polite as I can, so I apologize. I've known you a long time. Where in the SR zoning is there approval, allowance, or permission to have anything that's not a house, not a church, or not an accessory structure? I get it if it's an accessory structure, that's included in the zoning, but you're arguing that this is a structure that's not an accessory structure, it's something else. Where's the authority for that?
Correct. There is nothing in the zoning code that would have any authority to consider it differently.
All right,
If
thank
it
you.
was considered as a whole, as a structure.
Thank you.
Anybody else before Mr. Kellner speaks? All right. You're up.
Well, thanks, everybody. This is a little different than I'd expected. You know, when I talked to Carlos and then got involved with Paul and the others about this process, I don't know that I fully understood the breadth and depth of what we're doing here. So I don't have a lawyer. I've talked with my lawyer over the course of time as it relates to this stuff. And I think it's very important. You know, I've lived in a lot of places. I own my own company. I bought this property 2 years ago. And I bought it with it being overgrown. The real reason that I found it pretty neat is because it's a ranch house in the front, as you saw on the would someone be able to pull up the survey that shows my property for me? I don't know that I don't have it, but that would help me to describe some of this, because then I'll show you guys some pictures and you'll be able to see. Would someone be able to help with that?
Carlos,
Yes, bear with me 1 second.
working on it.
thank you.
Oh, that's terrific. Thank you. And then if you could just scroll down, yeah, just scroll down to where it shows the property. Oh, that's terrific. Thank you. So when I bought the property, it's a ranch house up in the front, and the back, if you look at the way it's laid out here, I guess you can't see my pointer because it's Carlos's screen. Oh, I could share my screen though, couldn't I? Let me do that. Host disabled.
1 second.
I guess I could describe it too. If at a point I could have the ability to share screen, I'd like to show a couple pictures and some stuff.
Okay, sir.
I now cannot see what was shown here. Perhaps I can pull it up again. Can you all see that image on your screens?
It's not popping up, Mr. Kellner, yet.
Yeah.
Yeah. All right, welcome to Zoom. Okay, here we go. I'll start with this. This will be helpful, I think, to provide some context. Can everyone hear me still?
Yes.
Yes.
Okay, I apologize for the delay here. So there, you saw from the map that this is a very unique property. It's surrounded by a lot of houses, all backyards that touch up against it. There are no front yards that touch my property, only backyards. There are approximately 12, maybe there's 13 that touch it. But within several miles of right here, it's unique in that it is about 2 football fields deep. It goes off of North Warson Road. It's about 160 feet wide, 170 feet wide, about 650 feet deep. And if you look at where my house is, it's up in the top corner. Everything behind my garage. So if you look here where the garage is located, everything behind my garage was overgrown. There was some grass back there, but it was 30, 40-year-old honeysuckle back there. Lots of erosion damage from water runoff that comes off of Lisa Drive that had been doing that for years. It was unusable. But what it did do for all the years prior to me purchasing the property is it provided an enormous backyard for all the folks who live along Lisa Drive, who had, their backyards were effectively this nature preserve of 30-foot tall honeysuckle. And in 2018, in November, I purchased the property because I saw the potential to clean up what was back there, put grass down and use it. I'm an active person. I coach baseball. The baseball team that I coach is a Fellowship of Christian Athletes team. I'm an ordained minister. I'm also on the board of FCA. I've done all the work in my backyard myself while I've lived here since 2018. There's a lot of context that comes with understanding that this backyard was overgrown and directly adjacent to all the backyards that we're discussing tonight with the folks who've challenged my right to use my backyard. Miss Little, I've spoken with her only one time in those 2 years. I'm back in my yard working a lot. At any time, people could have come to me and talked about what I was doing, what I was planning. I'll show you in what I'll show next, my perspective on what's been said, what's being alleged, and also what my intentions are. But it's very important to understand that along this right-hand side, as you go from top to bottom of my screen, 0 Lisa Drive is just next to my garage here. And then 1, 2, and 3 are down here as you move your way down. And then here in the back is, Liz Little is down here. And this is, here's where you see the posts and the permit. They're right here. Now, when I tell you it was overgrown, it was not just overgrown on my property. Their backyards were also, there's a buffer of 30-foot tall honeysuckle that was between both properties. I just cleared a lot of mine out. Liz Little, for example, their yard, they had honeysuckle that was the same height. So when I originally was going through this process and trying to figure out where to put the net so that I could throw batting practice to my kids, both of whom were pitchers, you couldn't see her house for 9 months of the year because it was screened. And you'll be able to see in a picture, there's another neighbor who's adjacent back there, Beth Wadsworth. I've actually I've developed a really good relationship with them over time because we've talked about what I was doing. And as I've been back there working, it was understood that when I bought the property, it's my property and I pay the taxes on it. I have the right to use and enjoy it according to what the law says. And so starting in November of 2018, I've coordinated with the town on how I've cleaned up the honeysuckle, on how I've cleaned up the backyard, got it ready for grass, and also on the notion that I could use my backyard to play baseball with my boys. And unfortunately, this has become pretty twisted as it relates to what are the motives and the stuff about noise. And I want to address the issues about noise. You know, town ordinance is very simple about what you can do during the day. It's also pretty straightforward about the kind of activities you can do in your yard. And when Mr. Kling was sharing how he thought this was, you know, my impact on the neighborhood, this is not a commercial facility. This is not a 24-hour-a-day full-on exercise in trying to make as much noise as we can. There are no lights that I'm you know, going to put in. There is no. There's a lot of fear mongering in the what if, and so I'm gonna show you guys now. I think it's a good time to show you what it is that I've talked through with the town, and this is a process that's gone over the course of almost all of the 2 years. I've worked with Carlos, with Barb Sondag. Paul Martin was brought in at the end of the process because we wanted to understand, hey, is it okay for me to use my yard how I would like to? And Paul Martin, after looking at the code, after considering how the town rules work, said, yeah, you can put a net in your trees and you don't require a permit, and you also don't require permission. Now he qualified that to say that if you wanted to add posts, then there would be a permitting process associated with that. We were in a meeting that had Barb Sondag in it, Carlos and Paul on Zoom, where we covered that. And that was the last step before I went forward and put posts in and purchased the rest of the materials to put the net in. So now what I want to show you all is, I'll show you some images and a response. I put a document together earlier today, after speaking with you know, back and forth on email when it was 3 lawyers and me talking. What I want to do is I want to walk through some components here that I think are very important as you guys are thinking about what it is that I'm doing with my yard. Right? It's a large yard that was overgrown for 30 years. That growth that was inside of the boundaries of my property provided tremendous privacy to the neighbors that are around my yard, provided lots of quiet, provided a false sense of seclusion that was real for all those years. And as I have worked with my hands to clear up my yard so that I could use it for my children and me as my home, I've coordinated with the town in all the steps that I've taken. There's nothing that I've done that didn't involve the town, that didn't have the town's permission or didn't have the town's input. And I did not move forward on any of these steps where I spent money and effort and time. My sons and I put those poles in after we were told that it was okay by the town. And after we shared everything that we were doing and what we were planning on doing. So I saw the original challenge, and it's, you know, about 130-page document, and there's a lot in it. And that narrative about what my intentions are is false. You know, I've been sworn in, and, you know, none of these people have had direct conversations with me as I have worked with the town, as I've been out in my yard on weekends doing this work. They have not asked me questions. They have not talked with me. They've not sought clarification about what I was doing. And that's concerning, because much of what they've said, while it may be a truth that they, in their minds, that they think is a reality, I have the right to use my property. And the town has rules about the kind of noise that I could make when I use my property, and the times that I'm allowed to make that noise, the kind of things I can do. I can have kids over to play. I could have a pickup game of baseball right now. I've thrown batting practice to my kids since being here, you know, and Mrs. Rochester made a comment about we don't want balls flying in the air and hitting our children. Exactly. That's what the net's for. And then the fellow who I forgot, I was taking notes and I misplaced, Mr. Van Allen. I don't know that I've ever spoken to him. But you know, again, he's along this line that has honeysuckle and bushes and growth between my property and his. And I have not done any clearing anywhere other than on my yard. I've not done any work anywhere other than on my yard. And so this is really important too, because you know, I moved forward with the town. I didn't move forward by myself. I didn't try and sneak anything by anybody. I didn't not disclose what my intentions were. I work directly in a forthright way with the town, and I have on lots of other things too, which, you know, isn't involved in right now. But if I want to hang a private batting net from my trees in my large backyard, which is private, Paul Martin said that's fine. So I guess at issue today is whether the poles in the ground force this to become more than what it needs to be. And we can talk about that because I want to show you what it looks like. But you know, hanging a net from the trees is much different than having a commercial practice facility with fear mongering that I'm going to bring, you know, hundreds of people through here. My teams, we practice at 314. My kids do go to school across the street. COVID-19 has changed how well we can use public facilities. COVID-19 has changed our opportunities to go out into the world and do things that used to be very normal. And I am blessed that I have a yard that's big enough to hold my kids with room, and that I can use for things that had I a smaller yard, I wouldn't have the opportunity to do. And you know, none of the things that I'm doing are on anyone's property but mine. And according to the town and the town attorney, after coordinating with them through the whole process, you see here, you know, Mr. Kellner, your use has not been approved by the city, in quotes. The upshot of the city's consideration is that no approval is necessary under the city code for you to fix the net to the trees on your property. So this was as Carlos was going through his process of trying to determine how does this fit, because no one, I don't know that there are many almost 2.5 acre lots in Olivet. You know, I don't know that anyone has ever wanted to have a net in their backyard. I want to play with my kids. I want to play baseball with my kids back there. And so a net is a way to make sure that windows don't get broken. A net is a way to make sure that it's contained in a single area. A net is a way to do it safely. And it's an activity that I'm allowed to do in my yard, regardless of if there's a net there or not. Just like I can play basketball on my driveway, or I could play a pickup game of football with kids down there too. And the fact that I have space, and the fact that I've approached this in the manner that I have in lockstep with the town, is not a bad thing. It's a good thing. So I chose to add those 4 poles on the as end poles in the ground after going through this process. And however, it's really important for everyone on the phone to or on this call to understand, those poles aren't necessary for what I'm going to do, for what I've suggested, for what I've told the town, for how I present it to them, and I'll show you guys. I'll show you guys some pictures that'll help you get a better understanding, because I think that'll help. But you know, the factual errors in this narrative are significant. This is a personal use item. The fact that the town hasn't ever had someone who asked to put a batting net in their backyard doesn't mean it's a bad thing. friends in other places that have their own as well. So working with the town to establish how to do it in a way that would work, given the property that I have and given my rights to use my property. Well, that was the process that we went through that ended up with Paul Martin letting us know that you know, directly attaching it to the trees is okay. You know, and this notion that there's infrastructure and there's going to be cars driving in and out of my yard and that children are at risk, that is absolutely false. People are not, first of all, I'm on private property. One of the reasons for the privacy fences that are also a part of this permit that were issued is because of issues that I've had with the Rochesters, in particular, Sean Rochester, which are well known to the town. And I'll let you guys know this because I submitted some things about 2 weeks ago. I had to submit a statement to the town because Sean Rochester attempted to, he pressed charges of disturbing the peace against me. He's called the police to my home about a dozen times. And you'll see in the record that each time it occurred that the police didn't find anything and they left. No report necessary. And it's in the record, but the idea that resources will be wasted because of me is silly. I'm not attempting to use this net after hours. One of the things that Paul was very clear about is it's important when it gets dark, the town should be quiet. It is a residential place, but during the day you're allowed to do stuff. Since I've lived here, number two Lisa Drive has been under construction almost the whole time. Two houses to my south, 476 and 480, were completely raised and new houses were built that are almost as big as the whole lot. There's hammering, there's trucks, there's all kinds of stuff. There's noise during the day in a real town. And, you know, to suggest that I'm going to make such an enormous amount of noise with a residential private net in my backyard that's surrounded by over 2 acres of property, it's hard. It's a hard thing to say would be a realistic scenario. And so I put these pictures together because I think they're very helpful. You saw the view from Liz Little's yard or her backyard, but here's the view from my backyard looking down at the poles. And so I chose this area for a very simple reason. It's because in working with the town, it was determined that I could use this area to hang a net. It would be a low profile, low footprint, use the natural trees, use the area there that's flat. It's tucked away in the back corner of my property. It is next to the Little's home, but it's my property. And those trees, were I to not have those poles there, it would not change my ability to hang the net there and have it work just as designed. I added the poles for a couple of reasons. One, because I applied for the permits and they were approved. I think they're beautiful. They're aluminum. I put them in to make sure that that it would have a finished appearance. To say that my work in my yard would hurt the town value, I think is absurd. I've cleared the lot and it looks like a park now. And what I took out of it was honeysuckle and lots of other overgrowth. I've cleared up erosion that comes from Lisa Drive. I still have an ongoing issue with that. But as it relates to this area right here, you see there's nothing that connects the posts. It's between these trees where the post's not there. The trees are still right there. And this area, why is it so long? You need 60 feet, 6 inches plus some room so a kid can do pitching practice. And so, on 2+ acres to have a space like this in my yard, that's not an unreasonable thing to do. And by the way, it's my right to use my property. And, to imply that my use of my property is going to destroy people's ability to use theirs in something as limited as, an activity that might be a few hours a week at most, it just doesn't make sense. So this area is where the trees are. It's where the posts were put in based on the permit and based on, you know, coordinating with the town and Paul. And then, you know, here you have, this is the extent of what it's going to take. It's, some of the numbers were incorrect. You know, the footings are not 18 inches wide. It was, I think they're 6 inches wide. It was a standard drill bit that I also used to drill the post holes for my 4x4s that are going to put up for a privacy fence, you know, on the north, farther up on my property. So it's, you know, some of the numbers that have been thrown around are wrong. This is the stuff that's going to connect it to the trees. It's, you know, there's the wire. These are, I think, 1 inch eye hooks, you know, snap hooks. And then these little silver guys are what would clip into the net and hold it to the wire. And then here's the wire. It's black, it's see-through, doesn't block anyone's view. It doesn't block any light. It doesn't weigh much. And again, you know, the steps that were taken to get to this point occurred incrementally and sequentially over 18 months. And I've honored the town's rules, the code. I can't control for the fact that that neighbors, you know, who live near this property before I owned it, really enjoyed the fact that they had a lot of extra backyard. You know, I would love to have a beer with people and get to know them and talk with them about stuff. You know, it took a long time to get the work to the point where it is, to clear it all out. I did it by hand. It's effectively done. And, you know, now I have a large open space in which, after working with the town, I've put in, you know, in one of the corners between trees, a net that I want to use for my kids. And when I was talking with Carlos about it and the fact that the town doesn't regulate activities on the property, there's, you know, there's laws about what you can do. Yeah, I can play baseball on my property. I can throw to my kids. I could do lots of stuff. I've got a large backyard. You know, and without a net where we just start hitting baseballs, there'd be baseballs that would fly in different directions. So, you know, to me, I think the pictures are really important because I am blessed with a very unique piece of property that for a very long time was overgrown. And 2 years ago when I purchased it after talking to the town about what I wanted to do. And then over the course of time, as I've cleared it up, you know, and this net is not commercial. It's not egregious. It's not anything more than a place for me to practice with my kids. And in a world where we don't know when we're going to be able to have normalcy, I have the right to use my large yard for activities that I'd like to, as long as they're within the rules and the law, which this is. And again, I you know, I apologize for taking so long. I think, you know, again, I'm not a lawyer, but I have done this all myself. I have worked with the town the whole time. I was very careful. I've spent a lot of money and a lot of effort to get to this point. And I did it because the town said I could. And I did it because I coordinated with the town as I was doing it. And I did it because when I asked the town, what should I do next? And they said, you should get a permit and write down the things that you want to do. I did those things and I paid the money for the permits, and I put the stuff in with my hands with my kids. And so, you know, I'm a family guy. You know, originally I thought it would be wonderful if the people around me would also want to participate. But it's become, at least to this point, clear that there's a confrontational tone, which I think is the wrong way for this to work. I'd prefer that we could be more collaborative, but you have to talk to someone. You have to ask them what's going on, and you have to coordinate with them. And you can't just create a narrative that you then shop around to other neighbors. That's false, and get people afraid that things are going to be very different and that there's going to be a commercial. I heard someone say that I'm going to bring teams through. Why don't I go to a professional facility? We go to the professional facilities. if we're gonna go do that kind of stuff. This is for me to use in my backyard, and I have that right. So, you know, I suppose that's not how lawyers would do it, but I hope that helps people to understand my perspective, the steps I've taken, you know, what this looks like in my backyard. You know, and there's one or two people maybe who have a line of sight view of it in a way that it changes their backyard view, but it's my yard. And the yard used to be separate. The yard used to be completely filled with honeysuckle on both sides. So, you know, to me, this is about what do I have the right to do with my property since I've purchased it and since I've coordinated with the town to do things that the town allows me to do on my land. A batting net just lets me do the batting stuff more safely. So,
Perfect. I appreciate it. Thank you.
okay.
Questions? Board, now it's our time.
Hey, this is Adrian, and again, apologize for the video. I'm working on the road, and again, apologize I don't have my video capability. But I was curious for Mr. Gellner, just because of some of the way that the presentation was made initially, and then how, you know, sort of hearing you out. It sounds like you intend to, you know, I'll say, play sports with your children during normal hours, right?
Yeah, so when I was working with the folks in the town, you know, one of the things that's really clear is there is noise when you're back there doing stuff. And so I was explicit that I'm not going to have lights. We're not going to do this stuff at night. You know, it's just a daytime activity. That's all.
Is there an intent, and this is a little off topic of what I'm just trying to understand the situation. Are you going to have professional pitching machines out
No.
here?
Well, I mean, I've got a pretty good fastball. But
and in terms of sports teams practicing at your home, that's how it kind of was made to sound initially, is like, I mean, the images I saw seem to be of, you know, a professional batting cage, and that doesn't seem to be what is going on here.
No, and it's really, and that's why I wanted to show you guys pictures, and I wanted to talk through this with you, because when I started, the backyard was a jungle. And this image, if you can, am I still sharing my screen? If you see it here, I mean, the amount of work it took to get this to here, that's when the people are when the neighbors are talking about noise, that's all the sweat equity that went in to clean this out. And that's done. And it's now, you know, I planted grass, it's growing in, you know, in the petition that was sent around, the 130-page thing, it talks about me putting a parking lot in the back, that cars are going to be, I'm going to put in a road. There's, you know, the only thing they didn't talk about was the Ferris wheel and concession stands, all of which is false. It's, you know, it's a 2.5 acre lot almost. This is the back left-hand corner as you look down from my house. Between the trees, it's level. I put some extra dirt in there so that it would be level. I'm going to be the guy pitching. There'll be an L screen, you know, or my kids will pitch to each other. Carlos made a couple of points, and I want to, you know, the town has really worked with me a lot. There's been a lot of stuff. There's other things. There's other legacy things with my property. I'll say this just because it's important for folks to hear, I think. The same folks who are arguing that I can't use my property how the law allows are also the people who live along Lisa Drive as a street, which has a non-legal outflow pipe in my backyard that dumps the stormwater from Lisa Drive out of all their grades. So it's 850 feet long as a street, 20 feet wide, or 30 feet wide. Every time it rains, all the water from Lisa Drive goes flowing down that street into those vents, and it comes out of a concrete pipe into my backyard that MSD doesn't have an easement for, that Olivet doesn't have an easement for. And I spent a lot of time working with Carlos in the town to remediate that, because every time it rains, it obliterates the backyard. And those yards, all those people on the petition, all their backyards, all the water that runs off of their roofs and out of their downflow pipes and out of the pipes that they run from the downflow pipes back to the back of their property, which touches my property line, it flows water down the back of my yard, which has a slope, and it obliterates my yard. And I've worked with the town to remediate that at great personal expense. And a lot of the work I've done has been to find a way to get that water to stop flowing how it has. MSD is not interested. There's lots of issues with stormwater drainage and funds to remediate the old issues, right? Think about it, this backyard for 40 years hasn't been touched. And so stuff that was going on for all those years, nobody knew about. And when I bought the property, the survey didn't have it on it. It wasn't until I started hacking into the jungle that I found it and realized that it was obliterating my yard, and it also flows downstream. And there's there's a couple of properties, because the low point of that area is south of where my property is. But you know, there's lots of stuff that comes when you buy a place that hasn't been touched for years. And we've heard from neighbors that they're frustrated that there's been noise as I've cleaned up my property. No one's ever really come and talked to me. The only person who's addressed it with me is Sean Rochester. And he has called the police. He's threatened me, it's been really a weird scenario. Just for, I'm 6'9", 250 pounds. And I'm a very gentle person. And he has been very aggressive with me. And while his wife it seems like a nice lady, and she did bring cookies that first day, that was the last time that I've had a reasonable interaction with that household, primarily Sean. And again, the narrative that's been put forth is so abjectly false in this process by the folks along my northern property line. Had they just talked to me about it, I don't know if you guys read the emails that were sent from other people around the town, in the vicinity. I did. And the only way that you write emails like that is if you are told things that aren't true, because the things that are in those emails about their privacy being infringed on, their peace and quiet being disturbed, whether there's a net or not, I can go in the back and hit baseballs with my kids, and so that's as much to protect those houses that aren't, that are north of my property line as it is for me to have a place where I can go down with my children. So I apologize for not being a lawyer, but
no, I understand. I didn't mean to get off into the weeds. I know there's a lot more going on here than it's appropriate for us to even comment on. I mean, we have a somewhat simple, complicated thing to deal with, but understand that this is not a commercial facility in any way, shape, or form, nor are you proposing to use it that way.
No, there are no lights on it. There's going to be no cars back there driving around. They'll ruin the grass that took me 8 months to plant.
I'm clear, and thank you for the explanation.
Thank
Are there
you.
other questions for me?
That's what I was just going to ask.
Okay.
Anybody from the board before, ask questions now, and then we're gonna make a decision.
Hey, can I?
Go ahead.
Oh, no, I'll let you ask, because I don't have any questions, Mr. Kellner. I would like to ask Carlos a question or two now, having listened to.
Yeah, I have a question for Carlos also, but I have a question for Mr. Kellner. Is there any specific reason? I know you mentioned the trees, but you have this very large piece of property, the 2.5 acres you said. Is there any reason why you put that structure or poles in that back corner that literally just sort of rides along that neighbor's one property, end to end pretty much? Was there not any reason to make it more private for you as well as the other neighbors, to push it more into your property, away from property lines? I still have to get into the whole thing of am confused why post holes for this netting structure is on the same permit as a privacy fence. I'm still all confused about that, but the fact that you put it in that place, was that really the best place? You know, how did you come to that decision?
Thanks for that question. It's a really good one. And there's a real straightforward reason. This area, am I still sharing the picture?
I see the permit on my end.
Let me go ahead and switch back then to, let me see about, because I'll show you why. Share screen. Oh, I've been disabled from screen sharing. May I please have the power back?
Set?
Okay, thank you, whoever granted that to me again. So if you look here, so as Carlos said, that there has, no one's really, this doesn't fall, I've worked with lawyers but not in this context. And so there was a lot of technical talk about, have you ever had a net, has this ever been put up in the town? Is it listed in the code exactly? And the answer is, there's probably not another one of these in Olivet. There's probably also not another yard like mine. And so by working with the town, it was determined with Mr. Martin that the way that I could put this, the way I could do this, that would be the most straightforward, and the way that would be allowed based on what the town law says today, was to hang it from my trees from 1/4-inch galvanized aircraft wire, and then that would be a way I could do it that wouldn't cause lots of trouble, because that, I'm not trying to go to court. I'm not trying to
Brought in the posts. I mean, the trees were part of your initial plan, but these
Right, and-
posts are the sticking point, because now you're building little foundation, and these posts
Right.
are,
So
straddle a fence.
I said, because, well, one of the things that I've coached baseball a long time. I love baseball, and instead of it, I could cut those. I spent a lot of money and time putting those posts in based on working with the town. They're Schedule 40 aluminum. They won't rust.
Can I interrupt?
They look beautiful. They're perfectly plumb. And
Oh, I'm not saying there's anything wrong with
no,
the post.
well, I'm sorry.
Matter of
The reason
why are
the reason
why
for
is
the
it-
location.
yeah, the location, just 2.5 acres is
I
really
apologize.
big property. So is there any specific reason why?
The
it's
reason for the
not-
location is because Mr. Martin, when we coordinated on this, would be a way that it would be allowed.
So it
And
had to be
so
in that.
that's why I chose there. And then when I requested, it's also flat. It's also shaded in the summer when I'll be using it, because the tree canopies are all over it. Like these are pin oak trees that they're 100 feet tall, probably. They're huge. And when they're blooming and when all the foliage is in, it's shaded back there. So it's a place to play, and it's a back corner tucked away that's away from everything. And so when I coordinated on it, it was, that seemed like the best place to put it. And so that's where we put it.
Okay, thank you.
Any other questions for the board, please?
I have a question, Mr.
Go.
Kellner. Are you going to be doing anything to the ground? Is there going to be any kind of flooring, pavement, or turf in this kind of under where the netting is going to be, or are you just going to leave it as kind of the dirt that's there right now?
What I'm going to do is I'm going to mix a little bit. I'm going to mix in, I've got, if you can see here, if I'm still sharing the screen, this little
No.
here is sand.
That's okay. I can picture it. Yeah.
Oh, yeah. No, it's going to be dirt. It's going to be a
Okay,
net.
dirt.
It's a net that hangs over dirt, period.
Net.
There's no lights, there's no nothing. It's just a net that hangs over dirt. and I added the poles because when I worked with the town and they issued me, and they said that I needed to have permits for the poles, that they were safely installed. It wasn't that it was a subordinate step to my right to put the net in the trees per pole. So it's going to be dirt. It's effectively going to look like that, except for there'll be a black net there.
Okay, thank you.
Will the net be attached to the trees and those poles? Or now that the poles are there, is it only going to be a perfectly rectangle netted structure? I'm going to call it a structure with the 4 poles.
So
So do the trees have anything to do with it at this point with the poles there?
I'm a little OCD, and so I want it to be really neat. I want it to look neat. So those poles I put in, so the reason I have this view is because you see the straight line of trees that goes here and the straight line here. So what I'm going to do is I'm going to put these eye hooks in those trees, and I'm going to string this cable through the eye hooks, and then I will use these little snaps down here to attach this net to those to that wire. So there's lots of ways that you can make a batting net or a batting cage. The professional ones, they might have 6 or 8 poles along the sides. They'd have structure across the top. I can use the trees for all that cross structure, and I can also use the trees for this linear structure. But
So your final plan is to use the trees and the poles to string the netting to hang.
yeah,
Okay.
yes. So the trees now, because the poles are in here, instead of having it, instead of putting in multiple poles, I can have cross, invisible galvanized line going this way, side to side, and then I can have the one wire on each side going end to end, and then the net would hang from that. Were I to take those poles, were those poles not to be there? Had I not gotten permission to put them in and hadn't spent the money and time and put them in, my plan was to run the galvanized wire from one end to the other on both sets of trees through those eye hooks, and then put cross wire that way, side to side on the short distance, and hang the net that way. So either way, it ends up getting me to the same outcome. But I decided to add the poles after the fact because it was determined that each pole itself would, they had to be put in safely in the the concrete they had to be put in and the way they had to be installed. It's an add-on to the process. Does that answer the question?
Yes.
Thank you. Any other questions? Paul, can we go into a closed session?
That if you want to, it will involve a delay. You're going to have to be sent a separate.
No, never mind.
Can I say a couple of things?
Please.
Number one, this is obviously different from what the Board of Adjustment usually addresses. We usually address variances, and that's not what we have here. This is an appeal to a decision by Mr. Trejo to issue a building permit for the poles. And that is a mechanism that state law allows so that a separate body other than the city itself can make a determination about whether the city did the right thing or the wrong thing. All right. Mr. Kellner often refers to his interpretation of what the law allows, but that's what this hearing is supposed to decide. If there is advice given to Mr. Trejo and he follows it, or if he makes a decision on his own, regardless, that's his interpretation of what the code provides. But what your job is to make a determination as to whether or not that interpretation is accurate. So that's what is presented to you today. Whether or not the decision to issue the building permit for the poles was erroneous or not. And the decision is that it was erroneous, then it goes back to the Planning and Zoning Commission for site plan review and community development, community design review.
Okay, I think we're gonna be able to make that decision tonight. Is there any other questions for anybody at this time?
I have a question or two for Carlos.
I'm sorry, member, who's
Mr.
speaking?
Zobo, I believe.
Yes, Mr. Zoll.
Yeah, go on, ask.
Go ahead.
Carlos, are you able to put up the definition of accessory structure under the code?
Yes, sir.
Thank you.
Okay, you should have the section up in front of you.
Carlos, there's been some inquiry about various structures of what's been approved and not approved and all of its history. Would something like a sunshade, whether connected to trees or if a homeowner decided to anchor it in concrete footings with a metal pipe, would that constitute a accessory structure?
Traditionally, we haven't treated it as an accessory structure. It depends.
Even though, go ahead.
The mass or so. Usually we take a look at it to when it starts to create some type of volume, some three-dimensional volume to that, because at that time it starts to become more of a building, which is traditionally what we've kind of addressed it. And through our code, and we did a major revision to our accessory structures section in the zoning code, trying to call out, all these unique type of structures that could be assembled and utilized on residential property in there. And most of those that are defined are either, again, have some three-dimensional form to them or have some significant flat work that's associated to them. Again, this one kind of falls in a gray area where you have posts, they're independent posts, they're not structurally connected outside of this mesh or fence or hanging wire, but that hanging wire isn't there for their support or structure. Somewhat different to what you would have in a pergola or a pool. It just became a review of where that classification would be and how it would be treated, independently of what was specifically submitted for that permit. And again, it goes those 4 individual posts being placed into the ground. And there was no indication of any other additional components that tied those 4 together that would be subject to a permit.
Okay. A pergola would constitute an accessory structure?
Yes.
And is that due to the patio base that kind of connects it underneath, or explain the difference?
Correct. You have a structured base, whether they're footings or some type of flat work, concrete, and that flat work can be whether it's concrete or it's a wooden decking of some sort. And then you have structures that, of course, extend above the ground, to go vertical, but then they're interconnected to one another through other members or forms. At that point, I have something that's all integrated.
What if the patio was already there and you put a pergola on top of it? And would that be considered a structure if you were already just,
Yeah, it would be considered an accessory structure. It would require a permit also in that process. And again, it's because that pergola all of a sudden is connected to the base. That base may already be pre-existing, or it could be something that's being proposed. And then there are vertical, the vertical supports are attached to that ground, and then there's something above them interconnecting those supports. So they're not independent of one another.
I'm assuming there is going to be netting as a ceiling on this batting practice structure. Is that correct?
Correct. What was described is that there's netting that's hanging from the overhanging limbs of the trees.
Okay,
And
it's all going to be connected as a box with an opening attached to a permanent pole that's, in the foundation in the ground. So it's not movable. Those poles are permanent,
correct.
dated to the ground.
That's my understanding.
So what is a fence? A fence is not just so I can clarify, a fence is not an accessory structure, right? Is that its own thing?
That's correct. It's called out separately in a different component in our municipal code.
Okay, so when you approved this permit that had a fence, the privacy fence, which I'm assuming is not built yet, and then these posts were added onto that permit, were these posts considered a fence as well?
No,
So I'm not sure how was it appropriated that the posts were just added onto a fence permit without there didn't seem to be any designated use for those posts, so it wasn't clarified what the posts would be used for. They were just sort of added on to the fence permit.
correct. And I'm not sure what the question is. So there was a permit that was active that was for the placement of the fence.
Right.
When there was finding that the posts were embedded in the ground and would require a permit,
Okay.
posts were added to that active permit.
So why wasn't that submitted as a separate permit, since it's a whole separate, completely different type of, it's not even a fence structure, it's just didn't have its own permit with its own designation of what it is and why a permit is needed for it?
It could have been applied that way. We saw that there was already a permit issued for the property, so we added that to that active permit.
Okay, just the poles just don't have any designated use in that permit, which is what makes this so confusing. This whole talk about netting being a batting cage, but the actual paperwork doesn't say, that I see, it doesn't say anything in that permit about it being some kind of, pole for this enclosure, whether it's a netting or not. It's just confusing what what we're actually debating here. I guess we have to define what exactly this thing is, because if it's 10 feet away from this neighbor's property and it's an accessory structure, then is it now entering the setback of that property if it's only 10 feet from the neighbors? And I don't know what those setbacks are, but now are we now encroaching on building, for a variance? So it's just really, maybe we can get some clarification on. I think first we have to decide what
I think
kind
that's what the petition is kind of alluding to, that the 4 posts, whether part of the permit or not, it's not necessarily the permit itself, but those 4 posts, the petition is expressing that based on their findings, that it is an accessory structure, and therefore it is subject to the rules and regulations governing accessory structures. That would include, and I think it's referenced in the petition, the setbacks, the size, the height, the placement, and even the approval process for that.
So it's within the proper setback, it's not overstepping,
If it's considered an accessory structure, it's
if it's considered.
correct. It is an issue that they would have to address.
And
Okay,
that's what we have to decide.
right,
You're deciding whether it is an accessory structure,
right.
but it's part of the,
And Carlos, the city has provided a few examples of what it does not consider an accessory structure. It includes flagpole and basketball backboard, correct? And post for basketball backboard, correct?
correct. We looked at it.
Are there any other, I'm sorry, go ahead.
We looked at providing 2 examples, one of the independent posts, let's say like the flagpole and such, and the other one being the basketball backboard, where you traditionally have a post that is either connected to or within near proximity to some type of flat work, because then that's what you use for as your court.
Okay.
And
Are there other examples out there?
there's light posts or,
None of those are 3D structures that a person can stand in with.
correct. Mhm.
Okay.
Aside from light posts, are there any other examples?
We looked at, or in the process of considering things in terms of how they're interconnected with each other. So there was references and there was questioning about whether the treehouse was a reasonable means. You could have a hammock connected by posts or hanging from a tree. You could have certain landscape type of awnings in a patio, the umbrella with, and things of that nature. As those structures become more complex, and again, looking at it when they start to evolve to that 3rd dimension, that is what that was in the decision process that we considered, of whether that had met that degree or quota or whatever you would consider it, or are these just independent? It was hard to justify that these were all interconnected in some form or another structurally outside of this net.
Okay. Aside from if Mr. Kellner took the posts out, but still desired to put the netting up and affix it to the trees in the manner to create this 70-foot by whatever the dimensions are, we would still be having this discussion of whether that constitutes an accessory structure, regardless of whether the metal poles were there.
It's hard to say, because then the form of the petition would probably be different, and we would be discussing of whether that activity, or again, I think there was references to because the trees are embedded in the ground, therefore they meet that the definition of a structure. I think, again, the perspective that we looked at, or from the review aspect of it, is we didn't see it in that same light. And then it gets down to, are we really regulating the activity that takes place in there? So if there's no net, if there's no posts, and they're having batting practice or throwing balls along that same area, is that regulated by the code? Is that an accessory? Is that activity accessory use?
So we're not here to talk about how noisy it is or how what type of activity is occurring within the 3 dimensions by which this netting is supposed to be there. We're here to discuss whether or not that netting in and of itself constitutes an accessory structure by which it would need to go through site plan review, correct?
That is correct.
Okay. And that's the scope or limitation, I guess, by which the board here is to decide. We're not here to talk about, although I'm not trying to ignore, I think some of the concerns. I think they're very valid concerns, but I'm just trying to make sure that when we render this decision, given the attention that all sides have delivered to this, that we are narrowing in on exactly what we're supposed to be considering and excluding some of the other matters, which again are very valid points, but they're probably outside the scope of what we're here to decide tonight, correct?
Go ahead, sir.
I'm sorry, if I could, I believe you asked whether your role here was to decide if the netting connected to the trees was an accessory structure. That is not accurate. Your role is to decide whether the netting connected to the poles, which are embedded in the ground, is an accessory structure. So I want to be clear about that.
I'm looking at so if I could just interject for a second, I was looking at doing some research on the definition of structure in the Olivet Code, zoning regulations, section 400.020 definitions. It says structure, anything constructed or erected, the use of which requires permanent location on the ground or attached to something having a permanent location on the ground, including but without limiting the generality of the foregoing: advertising signs, billboards, backstops for tennis courts, pergolas, radio towers, memorials, and ornamental structures. The word structure includes the word building.
But is that different? So I think earlier, Mr. Kling said that we had houses, places of worship, in so many words, and accessory structures were the only things that are allowed on SR zoning. I believe that was correct. This definition of structure seems to be a little different than that term accessory structure.
But the definition of accessory structure, and like if you was reading into it, refers repeatedly to just the word structure.
Mm-hmm.
So I would refer back to this definition of structure. I don't know if it has a permanent location on the ground. I mean, there's no ground, there's no flooring. It's the dirt floor, and it's a net that you can just lift up and walk under, right? You presumably can just lift the net from the bottom and kind of walk under it, and it's, you can see right through it.
Yeah, but besides the pole
But it's got poles
that are in the cement foundation. So
that are permanent.
that's the fuzzy part here.
I don't know. I think that's a stretch. I personally think that's a stretch. It's a bill. It's not a bill. It's either, I mean, I think it has to be more like a garage or an enclosed, some type of a building. I mean, I don't think it's contemplating netting in here. But a backstop for tennis court, I mean, that's, wood. It's,
Yeah, a backstop for a tennis court is more like a fence. I mean,
yeah.
More like a wall. This really isn't a wall. If you can have a flagpole or a basketball hoop, and those are not considered accessory structures, I understand what Carlos was saying. I mean, how do you draw a comparison to such a thing? It seems like Carlos's consideration was appropriate in terms of what they can draw lines to, this being somewhat unique.
And I agree with that. If it was a single pole for a basketball, but when you put up 4 of them and you can enclose it with a net, I think that's stretching it. Also, when it was applied for, and this is mentioned before, as a fence with a 6-foot height is the maximum fence that we allow, and these are 14-foot poles.
Carlos, is what was built or what exists, are these poles different than what you anticipated when the permit was issued or approved? it sounds like it was done in communication in conjunction with ongoing discussion, or is that not is what being said not actually the case?
Understand the posts as they're placed are reflective of the permit in hand. I'll note that the posts were installed prior to the permit being issued. So in terms of, once that was corrected, they reflect what's shown in that building permit.
Thank you.
What was that? The poles were put in before the permit?
Correct.
That's crazy.
Well, sorry, I'm just looking at other parts of the code here. Carl, it's not to change this up too much, but there's a definition for open accessory structures as well. I guess if we don't even have to get to well, I'd like to still see what that definition says.
Is this the section you're referring to?
Yeah, I'm looking through some of the reports that have been online, and there's some arguments here about whether it meets certain definitions, and I'm just trying to figure out what some of these terms refer to. So it looks like open accessory structures here would refer to these gazebos and pergolas. Can I ask you to, well, it says included but not limited to, what's after, is it A, B? Is there anything after A and B as you scroll down?
Gets into area height and setbacks.
Okay. What is a play structure? Can you move to that? Okay. Thank you for that.
So are we able to, does anybody else have any questions? I mean, I'd like to just talk to the board and see what direction we're heading. Paul?
Hold on. All right, go ahead, sir.
We still have one gentleman, Alan Roden, who would like to speak.
Okay. We'll let him be sworn in, please.
Okay, Mr. Roden, you should be transferred over as a panelist.
Thank you for allowing me to speak.
Could you raise your right hand, sir? You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So I'll be brief. I'm not a lawyer, but I am representing my father, Irvin Rodin. He's 88 years old. He has difficulty hearing and seeing, and he's lived at 31 Nantucket Lane for the past 53 years. So I think maybe contrary to some others, I've had several conversations with Mr. Kellner and have generally found him to be a pleasant person, but very determined to do what he wants, irrespective of what effects his wishes may have on his neighbors. So I must say, it is interesting for me to hear all of the potentially valid complaints from my father's neighbors here, particularly those that are addressing Mr. Kellner's disregard for his neighbors. That's consistent with what I have witnessed. And I'm hearing people saying that their views have been impeded, that they're being subjected to excessive noise, other things like that in the pejorative. And I've heard similar things from my father and the people who help him in his home. So the reason why I've been asking you now to hear me tonight is because I want to take this time to identify another problem that Mr. Kellner has caused due to his construction, particularly as it relates to the land that he has denuded and the resulting water runoff that's affecting my dad's property. So Mr. Trejo was at my father's house just a few months ago, and he witnessed this flooding and this water damage that's resulted from Mr. Kellner's so-called construction activities, particularly the flooding damage that's been caused to my father's swimming pool, which is clearly visible in one of the pictures that you all were looking at earlier tonight in the presentations. Now, this runoff and this mud that now plagues my father's pool every time rain falls was never an issue for the 53 years that my father has lived in that home, 52 of which I lived there or close to that. This water diversion that Mr. Kellner has created, including some questionable actions to MSD-owned runoff drains that he mentioned also, is another issue that the city of Olivet should be considering when considering what's within the rules of the law. And, you know, there's clearly a fine line between giving people freedom to do what they want in their yard and the effects that what they do in their yard has on their neighbors. There's also the concept of decency, being neighborly, and acting in a manner that I would say is appropriate to the environment that, in my experience with Mr. Kellner, he has no regard for. He's interested in what's good for him and him alone. And given everything that you have heard tonight, I too implore this board to reconsider this permit, to not allow this construction to continue. And I don't believe, I am an avid sports player myself, and I grew up in that backyard playing sports for many years. I don't believe for a second that that structure is going to stay with dirt. It's sitting on a hill. He's going to do something there. And by that time, you guys have already provided some sort of backing for him to do it. So again, I implore you all to reconsider, and reconsider very seriously also when Mr. Trejo, for whatever reason, has agreed to unmeritoriously. Thank you for your time.
Thank you. So I think we've heard a lot from everybody. Does anybody have questions for
Hold on
anybody
one
else?
second, Chairman, hold on. We're having some audio issues. Talk closer. The mic may be too far. I've gotten a
Can you
couple
hear
of
me,
comments.
Mr. Chairman?
Yes.
Okay, I wanted to point out that Mr. Hartman and Mr. Malik aren't on video. We need them on video to have a legal hearing and a legal vote. Thank you. All right. We have Mr. Hartman.
I'm here. Let me try to see if my cell phone can get a signal enough to do it.
Okay. All right, well, I want to just go back a little bit. Yeah, it's your job to decide whether the poles and the netting, I'm going to call it a facility, constitutes a structure under the code. Structure is defined as anything permanently embedded into the ground. Accessory structure is defined as essentially any structure or use that is subordinate to the primary use on the property, which we have here, residential use. So if you decide that it is an accessory structure, and I want to be a little bit more clear about this, I'm not sure if I have been. If you decide that it is an accessory structure, then we have to look at section 400.1592 of the code, which deals with accessory structures. It came up a little bit ago. And that section includes a laundry list of permitted accessory structures. And it includes another category of unenumerated accessory structures, an accessory structure that doesn't fit into the permitted areas. And the city has conceded that if you find that this is an accessory structure, it really doesn't fit in any of the other areas, and it would have to be considered an unenumerated accessory structure, which would then go back through a process of review for community design review and for site plan review. So I just wanted to be clear about that, because we've talked about a lot of things tonight, a lot of which isn't really relevant to these issues. But I wanted to be clear about what you're being asked to decide. And that is primarily, is this an accessory structure under the city code? All right. Thank you.
Thank you.
Chairman, if you can pause for 1 second here.
Okay, we have a problem with Mr. Hartman. He is not on video, but we still do have a quorum of 4 on video. And I think under the Sunshine Law that he can participate by audio as long as we have a quorum for the video portion.
Fine.
Okay.
All right, guys, we've heard a lot. Now I want to hear, unless anybody else has anything they want to add at this point, which is fine, but I'd like to find out what everybody's thinking so we can make a decision tonight. You guys are up. I'm really curious to what your thoughts are. Oh, by the way, we're closing the public portion of this meeting. So you guys are up.
I think the neighbors raised some very, very valid points. I think there's some serious concerns about a whole host of issues. And those are, I'm not trying to mitigate or ignore any of those, but I do think that we have a very narrow inquiry here. And I'm not necessarily sure that inquiry is able to capture all of those concerns. So it sounds to me like the netting affixed to the trees is not, and I hate to characterize it as the problem, but it's not necessarily the issue. It's the netting affixed to the 4 poles, which it sounds like the city has construed as acting independent of one another, and likening them closer, I guess, maybe to a basketball court, or a basketball, not court, but basketball hoop.
Oh.
Yeah, and less like a gazebo or something that's a little bit more integrated with its poles. And Carlos did say a sunshade wouldn't be considered an accessory structure, and to me that almost seems like it's the exact same thing. If maybe it doesn't have the walls, I guess. I don't know. I think that I do see how the 4 poles, when you start adding them all together, as Carlos said, it starts to operate a little bit more, it starts constituting a little bit more complex of a structure. And I think there starts to be a little bit of gray area. I don't know, it's close.
Next. Come on, speak up, guys. Go on, you're up.
I'm going. I think if it was a single pole in the ground and it would fall into that category of some kind of basketball net or pole, and it's one dimensional, I think that's one thing. But the fact that it needed a permit to put these poles in the ground with foundation makes it more important than just sticking some hockey net out there with metal poles that can be moved around. So this is something that needs a little more regulation, I guess. And the fact that there are 4 poles and something will be connecting it all together with a ceiling, to me, makes it an enclosed communal usage space that can't be just picked up and moved somewhere else. So I think as gray of an area, and thinking about a pergola, if I were to, build a pergola on a pre-existing patio, and that would be considered some kind of open accessory or considered an accessory structure, then that with open slats and 2 poles, I don't see why that's much different than enclosing 4 poles that are stationary in the ground with a ceiling. So I think that this does need more review for site planning. And to me, it falls more into an accessory structure than not.
Okay.
And I totally hear all of the concerns that the neighbors have, and I feel for them. But I know I have to just keep in mind that we're not, if he's allowed to do what he wants on his property, if it's in, if it's legal within the noise boundaries, the time of the day and everything. So we, that's not really what we're here for. It's a matter of, is that structure okay in the spot where it is on his property?
Right.
And are we here to say that that does need more oversight, or final decisions about whether that can be there or not in that particular spot, and that size and all the other dimensions that go into the site planning?
Adrian, we've had you there for a minute.
Hold on. I'm trying to do both video. Again, I'm in a remote locate. This is not ideal, but hopefully my words can come through. I mean, to me, it sounds like this is not an accessory structure. It more resembles a play structure, or things not governed under the accessory structure intent. And I don't, with what we've been asked to do, I don't believe that the permit was erroneously issued. I mean, I can follow the line of thinking. I completely agree that it's causing friction, but again, I don't know that that's what we're here to talk about. I mean, was there an error in issuing the permit, time calling this an accessory structure?
Could you repeat that last sentence?
Okay, Omar?
1 second. Chairman, 1 second. If Mr. Hartman can repeat the last
I
sentence.
have a hard time.
Sorry about that.
I'll kill the video so my words
Okay,
can come in
perfect.
better. I have a hard time calling this an accessory structure. I mean, I think that would be a stretch, and I do not believe the permit was issued erroneously.
Okay.
I would just say that, just reading the definition of structure literally in the examples in here, it's hard for me to come to the conclusion that this is an accessory structure, just given the fact that it is netting, it is, see-through. You could lift up the netting and go under it. You could clip the netting very easily with whatever the hook is, and the netting just falls. I mean, it's not even like a tent. The examples in here are like structures, I mean, that are, made of some kind of like material that really you can't see through, like wood or a building. The definition of structure includes the word building. So to me, that's the intent of this definition is to have it be a solid structure, like a building, like a garage, like a true structure, like a pergola or something like that. So I don't think this fits the definition of accessory structure.
Okay. I'm kind of, I understand what Carlos's thinking was. I mean, I do feel you're looking at needing to go for a site plan review, being that it is 4 posts in the ground. And that it was, I just have a bunch of problems with it, but basically, yeah, that it was put in on a fence permit. I understand why we did this. I also have an issue with the location, and I have problems with it. But bottom line, I think it's an accessory structure. How do we go, Paul? How do we go about doing this? We need a vote, or I mean, how? Because I think we're ready.
Well, I think that since the appeal is to reverse the building permit, I think you do need to have a vote. I think
Right.
and I would suggest a motion to sustain the appeal and to reverse the issuance of the building permit. And given what folks have commented on, it seems plain that what the result of that vote is going to be. But I think that's the motion that you need to put forth and make a decision.
Can somebody, and can somebody make a motion, please? Based on what Paul just said. Somebody.
What's the language of the motion again?
Can you suggest the specific Yes.
The motion would be to sustain the appeal, grant the appeal, and reverse the issuance of the building permit.
What if you want a motion against that?
It's easier to just have that motion and have you vote it down. It's
Got
just
it.
An easier way to do it. If the vote's going to go that way.
Got it.
Go that way.
I'll motion to sustain the appeal. And indicate the permit shouldn't have been issued.
Is there a second? Can I second?
Yes, you can.
I'll second. So how do we put it for a vote? We wrote roll call.
Roll call, that's it. Would you like me to do that?
Please.
Mr. Hartman. This is.
No, wait, I'm sorry, just to get clear,
Yeah, can you
if you vote
Yeah.
for it, so the motion is that we don't allow the variance.
Right.
I mean, don't allow the,
A yes vote is to reverse the appeal.
perfect.
Okay. A no vote is to. A yes vote is to reverse the building permit. A no vote is to
Leave the building permit in place.
leave the permit in place. Okay?
Is this a situation where it's majority or
Yeah,
do we need
4.
to vote?
Need 4 votes. All right, Mr. Hartman,
And nay.
Mr. Malik,
Nay.
Ms. Weber,
Yes.
Mr. Zobel,
Nay.
and Mr. Gerstein.
Yes.
All right. I may have to prepare an additional legal document for you. I would like to speak with the other lawyers about this, about the need. It's called a findings of fact and conclusions of law. And let me speak with them. And if I need to prepare that, I will get that to you and we will, you'll have the opportunity to take a look at it. And provided that it is accurately reflects your judgment here, then Mr. Gerstein would be able to sign that. And that's just for bringing this to a nice, neat legal conclusion if that's possible. But
No, it's not.
that's going to be necessary, but if it is, I'll let you know, okay?
Thank you. Yeah, it's, I've been doing this a long time and this was one for the record book here.
Yeah.
Okay, that's it. Thank you. The zoning board meeting, well, do we have city updates from Carlos at this point?
No, Chairman, and we don't have any meeting.
Thank you. I mean, sorry, no, that's awful. I'm going to adjourn the zoning board meeting. We're done here. Thank you, guys.
Thank you, Mr. Chairman.
Thank you.
Thank you.